We have breaking news in the United States Court of Appeals for the Third Circuit out of Pennsylvania, New Jersey, and Delaware. Specifically, the state of New Jersey is desperate to defend its quote-unquote assault weapon ban and has just submitted a major brief in an attempt to do so. And surprise, surprise, it's chock full of, in my view, lots of errors. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say one of the few people you probably know that actually has a Winston Churchill action figure behind me, right beside my Godzilla action figure, in case you guys are wondering what those are behind me. All right, folks, so here's the story. We have a major case pending in the United States Court of Appeals for the Third Circuit. That case involves the Association of New Jersey Rifle and Pistol Clubs, Mark Cheeseman, and Blake Ellman. These are multiple cases that are all consolidated against the Attorney General of the state of New Jersey. These cases are now pending in the United States Court of Appeals for the Third Circuit, which is the Court of Appeals that covers New Jersey, Pennsylvania, and Delaware. Now, this is dealing with the so-called assault weapon ban, dealing, of course, relatedly with the magazine ban of more than 10 rounds for rifles and whatnot. And of course, the state of New Jersey has just filed a major, many dozens of pages long submission to the Court of Appeals trying to justify their existing quote-unquote assault weapon ban, which at the end of the day is just a ban on ordinary semi-automatic rifles with various features that are, again, designed to help the shooter shoot more effectively, be more accurate, and shoot the gun more safely. Nevertheless, these features that New Jersey doesn't like is trying, of course, to argue effectively that anything that makes these things more effective for the shooter somehow makes it more effective for mass shooters and for criminals to do criminal things, and therefore they should be banned. Well, there's a lot of major mistakes in this brief, in my view. There's not a lot of new mistakes they're making. They're just a lot of the same major mistakes that other anti-gunners have made in the past. And until the U.S. Supreme Court or some other court comes along and corrects these, well, we're just going to have to deal with it. But let me go through, because it's very important to continue to correct mistakes where we see them, point out who's correct, and then eventually, over the fullness of time, I'm confident our side, in favor of the Second Amendment, in favor of freedom, in favor of the United States, in favor of America, will ultimately prevail in this battle for freedom. To begin with, this is how New Jersey starts off its argument. From before the founding until today, states like New Jersey have borne the solemn responsibility to keep their residents safe. That includes protecting residents from the modern scourge of mass shootings and from the extraordinary dangerous weapons that facilitate them. While the Second Amendment takes certain responses off the table, reflecting individual rights to have arms with which they can defend themselves, the right to keep and bear arms has never been understood as a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. Like a range of other states, and like the federal government for a decade, New Jersey therefore restricts assault weapons and large-capacity magazines within its borders. Every circuit to consider Second Amendment challenges to similar laws after Bruin has rejected them, citing to Bianchi versus Brown in the Fourth Circuit, citing to Ocean State Tactical versus Rhode Island in the First Circuit out of Boston, citing to Hansen versus District of Columbia out of the D.C. Circuit in the Court of Appeals for the D.C. Circuit, and Bevis versus Naperville out of Chicago in the Seventh Circuit Court of Appeals in 2023. All right, so there's a lot to unpack there in the rest of this brief as well. I'll put a link to it down below, see if there's anything I missed. But let me start off right at the top. The perspective that New Jersey has adopted is totally wrong from the beginning. Specifically, they do what all the anti-gunners like to do, including anti-gun judges, and that's this. They immediately try to tell the story of the right to keep and bear arms from the perspective of the criminal. They try to tell the story and delimit and define the right by how individuals misbehave and violate the law using firearms. This is not correct. This is like limiting or narrowing the scope of, let's say, the First Amendment's right to free speech, because some people abuse speech to commit fraud, to defame others, to commit slander or libel, or to do other things, to start wars, start fights, whatever it happens to be, that would otherwise not be protected by the right to free speech. But again, we do not measure constitutional rights by virtue of how people misbehave. We don't define rights or limit them or narrow them by virtue of criminals and what criminals do. And yet right off the bat, New Jersey's argument is essentially that. It's essentially saying, look, because people, certain psychopathic nut jobs, misbehave and engage in shootings and criminality, including mass shootings, that means we have a basis as the government to tell ordinary Americans that they don't get to exercise their right to keep and bear arms because some nut jobs do nutty things. But of course, as we know, going back to even before we were a country, our founding fathers, including John Adams and Thomas Jefferson, were both beholden and loved the writings of a man I've been trying to bring back to the fore of American life, Cesare Beccaria, the Italian Enlightenment philosopher, who literally said, before the Constitution was even written, that arms ban laws do nothing but make it easier for criminals to attack law-abiding Americans and law-abiding folks, because it's a lot easier to attack an unarmed person than an armed person. And since criminals are always going to have arms because they're not going to care about the law because they're criminals, you're only burdening and making it easier for potential victims to become victims. This is not an NRA slogan from the 21st century. This is literally from the 18th century Italian Enlightenment era, embraced by none other than Thomas Jefferson and John Adams and the rest of the founding fathers, and among other things, the Second Amendment's right to keep and bear arms. So right off the bat, New Jersey takes a misstep by embracing and are trying to define the scope of the Second Amendment rights by virtue of how criminals behave. That is not how we do it. That's not how the founders understood it, and that is not how the current U.S. Supreme Court does it either. Because if you look at, for example, the United States Supreme Court decision in Heller, District of Columbia versus Heller in 2008, Justice Scalia specifically said this. He talked about how Americans use firearms like handguns for lawful purposes, for common uses, for lawful purposes like self-defense. And the entire dissent by Justice Stephen Breyer, the dissent was all about how criminals misuse things. But again, the Supreme Court, in defining the scope of the Second Amendment in Heller, literally said it doesn't matter how people misuse firearms. That's not how we define rights, which makes a lot of sense. Why would I lose my right to keep and bear arms because some nut job 1,000 miles away does something nutty? Why am I the one paying the price? That is very anti-American to punish other people for the crimes of others when you have literally zero connection over such nut jobs. But New Jersey's brief goes on to make other arguments. Now, of course, they lean heavily in to this argument that says every circuit to consider the question about whether or not these quote-unquote assault weapon bans are constitutional and whether or not these magazine bans are constitutional have been upheld. But we all know the dirty little secret here, which is the reason why these anti-gun courts have historically upheld these laws, is because the only courts in America, the only courts of appeals in America that have an opportunity to rule on bans of semi-automatic rifles and magazines that hold more than 10 rounds are what? They're the same federal courts in the same anti-gun liberal blue state jurisdictions that are controlled by blue city politicians. The same politicians that are enacting these laws against guns are the same politicians that are hand-picking, by and large, the federal judges with the support of the president to sit on these courts. So you've got nutty anti-gun judges overseeing nutty anti-gun politicians enacting nutty anti-gun laws. That's why the result in all these jurisdictions, as a general matter, not entirely, but as a general matter, you see the outcome you would anticipate, which is these nutty anti-gun laws are upheld by anti-gun judges who were handpicked by anti-gun politicians. So here you have New Jersey leaning into the fact that the four courts of appeals post-Bruin have upheld these laws, but of course they don't tell you. They do tell you, but they don't emphasize the point that one of them is the Fourth Circuit Court of Appeals out of Maryland and Virginia, known to be a terrible anti-gun court. The second one is the First Circuit out of Boston, the world's worst court of appeals in America. You can't even find two Republican judges on that court. Never mind good on guns or good on the Second Amendment judges on the First Circuit Court of Appeals out of Boston. They're absolutely pathetic and terrible on this issue. Then you look at the D.C. Court of Appeals. That's the court of what? Deep State and Jack Smith. Well, geez, do you really think you're going to get a great ruling on the Second Amendment out of the D.C. Circuit? Hardly. And then what's the Fourth Circuit that this New Jersey brief cites to? And that's the Seventh Circuit out of Chicago. The Bevis decision, which of course was written, we've written about this before, we've talked about this before, where you have Judge Diane Wood, who's no longer a judge, thank God, and Judge Frank Easterberg. I don't know what happened to that guy, but it wasn't good over the last few decades. And that they, of course, took control in a 2-1 decision and overrode Judge Brennan in a 2-1 decision saying that the Second Amendment doesn't protect these types of firearms in these magazines and so on. So basically, New Jersey's saying, hey, look at these liberal judges upholding these liberal laws in these liberal blue state jurisdictions. And again, as you know, you're not going to get red state courts ruling on these types of laws because there are never going to be these types of semi-automatic rifle bans in Texas and Louisiana and Florida and so on, which means these courts in those jurisdictions that might actually uphold and follow the Second Amendment as given to them by the U.S. Supreme Court and by our founders. You're never going to get a chance in those courts to actually deal with one of these types of cases because, again, judges are reactive. They react to what's brought in front of them. They don't go out and reach for cases. The cases have to come before them, and you're never going to get an assault weapon ban case in front of these judges because there's never going to be a law enacted in the first place in these red states that can then be challenged in the federal system in those circuits. And that is the dirty little secret that New Jersey doesn't mention, of course, in their brief. Now, later in the brief, New Jersey makes another mistake, and they fly again directly in the face of the Heller decision from 2008. Specifically, they argue that, look, individuals in the state of New Jersey have the option to engage in self-defense, basically with handguns and other kinds of weapons. And because they have an avenue left open to them to exercise their Second Amendment rights for civilian self-defense, we can ban these other guns. But of course, that 100% is wrong. Because specifically, expressly so, the U.S. Supreme Court said in Heller in 2008 that just because the District of Columbia allowed people in D.C. to have access to rifles and shotguns, long guns, was not any kind of an argument in support of banning handguns. In other words, the Supreme Court says it is not an argument to say, because you let Americans in D.C. have rifles and shotguns, you can thereby ban handguns. That's not how it works. And that makes a lot of sense. Because if you think about it in the context of the right to free speech, that would be like me saying the following. Hey, look, I'm letting you have 500 books. You don't need to buy the 501st book or the 502nd book. Or you don't need to buy 5 Bibles. You already have a Bible. Why do you need 5 Bibles? You see what I'm saying? Same idea. You already have enough guns. Why do you need more? Why do you have, how many books is it just to be enough, right? I'm limiting you from the number of books. You can only buy 1 book a month because, hey, you already got more books in your library than you can read in a lifetime. Why do you need another book? Obviously, that doesn't work in the First Amendment context, and it doesn't work in the Second Amendment context, and that's essentially what the Supreme Court said in Heller. Now, there's a lot of other points that I can make about this brief, but I'm not going to belabor the point. But I do want to make another observation that, yet again, New Jersey does what all the anti-gunners do, which is they try to pretend and argue that the in common use test arises at the textual level and not at the historical level. They also relatedly argue that the burden, listen carefully, because this is a little nuanced, but I'm going to make you the smartest person in the room so you get it right, okay? They also are arguing that Americans, to show in common use, have to demonstrate that the arms are needed for common use and they're actually used. Not just owned, but they have to actually be fired, essentially. But we know that's not true because in Heller, the Supreme Court said that really owning handguns is using handguns, right? The handgun on my nightstand, the AR-15 in my closet, the handgun in my car, the handgun in my pocket may never be fired. May never be used. I might not even train with them. Nevertheless, the fact that I have them is using them. It's like life insurance or fire insurance or car insurance. I may never put in a claim on my car insurance, but the fact is that I have life insurance or I have car insurance or I have fire insurance. I may have never put in a claim on any of those, but I'm still using them just by virtue of having them. Same way with firearms, same way with fire extinguishers, same way with airbags in cars. You get the point. And that is a point, of course, that the anti-gunners want to skip over. Now, beyond this, and this is critically important to understand this, as I've told you, the anti-gun movement is desperate. If you look at the scholars and all the anti-gun literature, they're all desperately trying to argue that all the fights involving the Second Amendment take place at the textual level. The textual level. And why is that? You know why that is. Because at the textual level, the burden of proof is more equiposed or equivalent between the Second Amendment plaintiffs, the Second Amendment proponents, and the government. Whereby when you get to the textual level of the text first, burden shifts to the government. To the historical level, when you get to the historical level, right? At the historical level, the burden of proof is entirely on the government to show there's a historical tradition of regulation to justify the modern gun control law. As a result of that, everything the anti-gun movement is trying to do today is to elevate every Second Amendment dispute about the law and its meaning to the textual level before the burden has shifted to the government. And they're doing that here. And this is totally wrong because they're trying to say that the Second Amendment advocates have a duty to argue that these semi-automatic rifles and these magazines are actually used for self-defense and are in common use for self-defense, and they do it at the textual level. This is totally wrong. We know that because if you look at Heller, the dangerous and unusual standard, which is the historical tradition of banning guns in America, that if they're dangerous and unusual, there's a precedent for banning guns. And as a consequence of that, if something's in common use by Americans for lawful purposes, it can't be banned because it's not unusual. If it's not unusual, it can't be dangerous and unusual. It's very simple. But again, where did all that stuff about dangerous, unusual, and in common use come from? That was the Supreme Court's discussion of the history of banning arms in America. In Heller, it was part of the historical tradition analysis. And at the historical tradition analysis, what do we know? The burden of proof is on the government at the historical analysis. So therefore, in an arms ban case, not only is the burden is on the government to show that the gun or the weapon they're trying to ban is dangerous and unusual, and therefore the burden is on the government to what? To show that the arms they're trying to ban, the magazines and the firearms, are not in common use. Do you see what I'm saying? The burden is not on the Second Amendment proponents to argue something's in common use and show it. It's on the government to show something's not in common use, because everything I just described, the gestalt of all this in common use, the gestalt of dangerous and unusual, occurs at the historical level after the burden is already shifted to the government. Because textually, an arm is anything that can be used offensively or defensively, which is obviously magazines and firearms. So textually, a ban on arms automatically implicates the text of the Second Amendment, which means the burden shifts to the government to do the historical analysis, and they simply are not able to do it in arms ban cases. But here, New Jersey is trying to argue, no surprise, that everything I just said about in common use and dangerous, unusual, and the use of these guns all occurs at the textual level, where they claim the burden is on the Second Amendment proponents to show all this, but this is simply not true. The burden's actually on the government at the historical level, and yet New Jersey's trying to play games here, and we'll see if the U.S. Court of Appeals for the Third Circuit allows it to occur. Hopefully it will not. We'll see, but I'll keep you apprised of this case. Of course, all this becomes moot if the U.S. Supreme Court grants cert in Snope or some other case, and let's hope that happens. All right, folks, there you have it. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe on Rumble and YouTube to this channel. Don't forget to follow me on X at Four Boxes Diner, and I look forward to talking to all of you again very soon here at the Four Boxes Diner.
Orders up. Table 2A.